Hi, I'm Annie Fitzsimmons. I'm your Washington REALTORS legal hotline lawyer. Welcome back to our video series entitled DB's Wish List. Listing and selling brokers should know that they are required to monitor buyer's deposit of buyer's earnest money and report if it is late. But too few brokers know why it's so important to seller to be advised if buyer's earnest money is late. Why is it important to seller? Why should listing broker, especially, be aware of whether buyer's earnest money is timely deposited and immediately advise seller if it is not? The answer to this question is simple and critically important to a seller and a listing broker. When a buyer's earnest money is due but not yet deposited, the seller has the right to terminate the transaction. Why is that so important? In a busy marketplace where seller may have a backup buyer or seller may just be getting additional offers coming in even after seller has accepted another buyer's offer, seller may be in a position to prefer a buyer other than the buyer with whom they've already reached mutual acceptance. And in that case, listing brokers, an opportunity for your seller to legally avoid the obligation to sell to the existing buyer comes when that buyer fails to deposit earnest money timely. As the question stated, hopefully every broker knows the importance from the buyer-broker's perspective, let's look at that first, of documenting earnest money. If the buyer-broker receives the earnest money from the buyer, of course we know that the buyer-broker is required to write a receipt. Often you use Form 89. I don't care, you can use any receipt you'd like. You write a receipt to the buyer, you give the receipt to the buyer, you give a copy to the listing broker, and you keep a copy in your firm's transaction folder. When the earnest money is then deposited with the escrow company, or if buyer deposits directly to the escrow company, either way, you also get proof of that deposit to the escrow company. Buyer broker, you keep that in your firm's transaction folder, and you send a copy to the listing broker. Now, this question is asking, though, not from the record-keeping requirements of the buyer broker's perspective, but from the listing broker's perspective. We know that buyer broker has to share this information with listing broker, but why is that so important? And the answer to that why is it so important question is what I said first out. If the earnest money is due but not yet deposited, seller has the right to terminate the agreement. Listing brokers, does that mean then that you should simply sit back and wait for the buyer broker to provide you proof that the buyer's earnest money has been deposited timely? You probably know I'm going to say absolutely not, right? Listing brokers, it's your job to protect seller's interest in the transaction. You need to be checking with the buyer broker once earnest money is due. If you haven't already received proof of its either the deposit from buyer to buyer broker or from the buyer broker or the buyer directly to escrow, if you haven't received proof of both of those steps in a timely way, then you should be inquiring. Maybe you want to ask buyer broker, or maybe if your seller's looking for the opportunity to terminate the transaction, maybe you want to go straight to escrow and ask escrow. If the earnest money is already due at the escrow company, then maybe your call should be straight to escrow to ask whether or not the earnest money has been deposited. Now, how do those time frames fall? Remember that buyer's initial deposit of the earnest money, either to buyer broker or directly to escrow, the earnest money is due from buyer to either the buyer broker or the escrow company within 2 days following mutual acceptance, based on the stated timelines, the boilerplate timelines in Form 21. So if buyer's depositing directly to escrow, it's got to be there within 2 days following mutual acceptance, business days. If buyer is going to deposit to buyer broker, deliver to buyer broker the earnest money first, then buyer's still got to do that within 2 days following mutual acceptance. Buyer broker then has 3 days from either the date of receipt of the earnest money or the date of mutual acceptance, whichever comes later. So in other words, in a situation where buyer may have delivered earnest money to buyer broker prior to mutual acceptance, buyer broker would then have 3 days from mutual acceptance to get the earnest money deposited with escrow. But if on the date of mutual acceptance, buyer has still not yet delivered earnest money to buyer broker or to escrow, then buyer has 2 days. They can deliver it to buyer broker if that's what they're doing. And then buyer broker has 3 days from receipt of that earnest money to get it to escrow. So listing broker, you've got to not only be aware of the timelines, you've also got to know how buyer's depositing. Is buyer depositing to buyer's broker or depositing to escrow? If you don't know the answer to that question, and by day 2 you haven't gotten a receipt, then you probably need to pick up the phone and call escrow and see if escrow has the earnest money. If they do, then that's the end of the inquiry, except for you need a copy of that receipt. If escrow doesn't have the money, then you do need to call buyer's broker and ask, has buyer deposited earnest money with you? Has buyer delivered earnest money to you? And if so, I need a copy of the receipt proving that buyer delivered the earnest money to you within that 2-day time frame. Because if the earnest money hasn't been delivered yet and it's due, seller can terminate the agreement. Now, the follow-on question that comes every single time is, okay, let's assume, however, that buyer's earnest money was deposited late. Let's say it was due 2 days after mutual acceptance, and buyer didn't get it deposited until day 3. And in the intervening lapse of time between day 2 and day 3, seller didn't terminate the agreement, but now on day 5 or 6 or 7, seller's got another offer they'd really rather accept. Can seller now terminate the purchase and sale agreement because buyer deposited their earnest money late? And the answer is no. Washington law is pretty clear. Seller has the right to terminate when earnest money is due but not yet deposited. Once buyer deposits that earnest money, even late, they have cured the defect in their performance, and seller no longer has the right to terminate the purchase and sale agreement. If you have questions on this topic or any other, send an email to me, legalhotline@warealtor.org. Thank you for being a Washington REALTORS member.